Hello. The purpose of this lecture is to talk you through how to answer a patent problem question. One of my students asked if I could go through this particular question, which comes from the 2017 resit paper, and in fact it's a question of two halves. But for reasons which are going to become apparent, I've got severe reservations about this question, and I wouldn't just advise you to steer clear of it if you come across it in an exam. I'd say you're not actually equipped to answer it. Nevertheless, I've invested time in putting together some guidance about it, which I would like to pass on. You might find yourself in the very unfortunate position of having to answer such a question, simply because none of the others appeal to you. And anyway, it's still a useful vehicle for talking through how to answer a patent problem. If you're doing the University of London International Programme, then it's a good idea to have a copy of the question in front of you. But if not, I'll go very quickly through the facts. The first thing to note, and this is what I think is the biggest problem with the question, is that it relates to a European patent application filed on the 1st of November 2015. If it were an infringement question, this wouldn't matter. But as we'll see, it isn't. So the substantive law which applies to the problem is the European Patent Convention, not the Patents Act 1977. And my understanding of the syllabus is that you have to know the Patents Act, but you don't have to know the European Patent Convention in detail. And except for one or two special areas like patentability of software, you don't need to know a lot about the case law. So just bear that in mind. The invention claimed in the patent is a genetically modified sheep. It's genetically modified so that its wool is resistant to moths. It's been developed in circumstances of at least some secrecy. The farm involved has limited access. Only employees of the company that have applied for the patent, that's Spigot Co, have got access to the farm. Except that obviously their security isn't that good, and a neighbour has managed to rustle some of the sheep and sold them to the local butcher. So I hope you recognise some of the issues that we're going to be talking about in this answer. But there's a quite gratuitous additional one, which is that this group called GM Warriors don't like the patent. I imagine from their name that they don't like genetic modification of anything, and they claim that 85% of genetically modified sheep are born blind. Given the secrecy surrounding this whole invention, I'm not quite sure how they know that, which is a relevant issue, because if they're going to fight the patent, they're going to have to produce proper evidence, but let's not get hung up about that just at the moment. So, as for the issues involved here, the first point to note is what the examiner asks you to do, and that's advise Spigot Co. It's fairly clear from the question what they're going to want advice about, but I do think that generally such a vague instruction isn't very helpful in examination circumstances. I must say I'm also surprised at the complexity of this question, or rather I should say this half question, because there is another part to it. For a resit, please don't do resits. Well, you'll pass first time, won't you? But if this is an indication of how difficult the resits are, they're well worth avoiding. One thing that's clearly not an issue here is infringement. And even if the examiner threw in some additional facts, there can't be an infringement because the patent hasn't been granted yet. It's only an application. And in general, that's a point worth looking for in a patent question, or indeed any other type of problem. Given the broad instructions which the examiner's given you, if there was an infringement involved here, then it would be legitimate, I think, to advise Spigot about what remedies they might have once their patent is granted. So that's a tip for a different sort of question altogether. This one doesn't disclose any sort of infringement, so that's not what you're going to be writing about here at all. Nor are there any ownership issues. The examiner hasn't put anything into the scenario to make you think about ownership. What we do have are issues about patentability. In a lot of patent problem questions, these would come out as validity issues, because most of the questions that have been set over the years have involved an infringement, and when the examiner asks you to write about infringement, the examiner expects you also to write about defences, and as the saying goes, the best form of defence is attack, and attacking the validity of a patent is a very important way of resisting an infringement claim. So the same issues crop up quite frequently in problem questions, and that applies to trademarks as well, which can be invalid, and also registered designs if they're part of your syllabus and they're not part of the University of London syllabus. So always remember that those topics go together, but not here, because there is no granted patent. We're not considering the validity of a granted patent, we're considering whether it can be granted in the first place. So the issues involved are the same as for a validity problem, but it's not framed that way. Had it been an infringement, notwithstanding the fact that it's a European patent, you would be able to apply your knowledge of the Patents Act 1977, but because this is an application that's still before the European Patent Office, you need to apply the European Patent Convention. And even if you've done a lot of dutiful study of the textbooks, I don't think you'll even know where to start. And even if you have studied the textbooks, you probably haven't studied the relevant parts, because the syllabus will have steered you away from them. So there are three issues which go to whether a patent can be granted. First of all, there's the question of novelty, and the facts make you wonder about novelty for two reasons. First of all, because the neighbour has rustled some of the sheep, and secondly because he sold them to the butcher. So both those individuals have seen the genetically modified sheep. Then there are issues about whether a genetically modified animal can be patented at all, and there are questions about public policy and morality, particularly in the context of this problem that 85% of the sheep are born blind. That point about blindness you need to recognise as a big signpost that the examiner has put in the question, pointing to the issue of public policy and morality. Then there's a further issue, which is what can GM warriors do about the patent application? The answer to that is that in the European Patent Convention system there is a 9-month post-grant period during which granted patents can be opposed. It's a rather curious way of going about it, and as you recall, it's the exact opposite of the way that trademarks work, because you have pre-grant oppositions there. The University of London module guide does contain a passing reference to the fact that there's an opposition procedure in the European system, but that's all. If I was marking this question and any student told me about that, I'd be fast-tracking them for a first. Well, you're asked to advise Spigot Co, and presumably they'd like to know whether they'll get their patent. I suppose it's pretty clear from the question that that must be what's on their minds. Because it's a European patent application, don't waste time telling the examiner what the Patents Act says. Well, I hope the examiner is humane enough to give you marks if you state the law correctly, but you're certainly not going to get many marks by proceeding on the basis that the Patents Act is going to govern the application. You might choose to answer this question by making it clear to the examiner that you understand the EPC as the governing legislation, but go on to say, thankfully the EPC and the Patents Act are identical in these respects, so I'm going to go with what I know. It's an option to explain the legal principles by reference to the Patents Act if you make the connection with the European Patent Convention. It's not a great way to proceed, but it would work, just so long as you make absolutely clear to the examiner that you know the EPC is the legislation you need to write about. In exam conditions, you probably don't want to be delving into the European Patent Convention, possibly for the first time ever, even if you've got your statute book to hand. That's just too time-consuming in the circumstances, and I've got to say this is a very long answer to half a question, so you're going to have time issues with it. The requirements for patentability are in Article 52, and the exceptions to patentability are in Article 53. Unlike the Patents Act, you don't open it and start reading at Section 1. When it comes to answering questions which involve validity or patentability, I think there's a lot to be said for the way that the University of London Module Guide approaches it, which is to deal with exclusions from patentability and exceptions to patentability. In other words, the negative criteria for patentability before you go on to the other three criteria, the positive ones. It would certainly be a useful discipline in practice if you're advising a client for real and they're paying for the time that you spend answering the question. They're not going to be amused if they receive a letter of advice which goes through the requirements for novelty and inventive step and industrial application, and only after they've paid you for all that advice do you get to the exclusions and exceptions and tell them that they're dead in the water anyway. Of course, an examiner is a different matter, and you've got to demonstrate your knowledge to the examiner, and it's rare to find that the issues are so cut and dried that the patent would be knocked out at the first stage when you're considering exclusions and exceptions. So you're almost certain to get the chance to carry on writing about the other criteria for patentability. Well, the exclusions in the patents legislation relate to subject matter which isn't patentable, subject matter which doesn't constitute an invention. That's discoveries, mathematical methods, computer programs, methods of doing business, and all that good stuff. It's the Patents Act 1977, Section 1, Subsection 2. That's where you're familiar with it from, but it's also relevantly for this question, Article 52.2 of the European Patent Convention. I think, given all the other difficulties you've got with this question, you simply say to the examiner there are excluded subject matter set out in Article 52.2. None of them appear to apply here. Let me get on to Article 53, exceptions to patentability. You'll be familiar with the equivalent provisions in the Patents Act, Sections 1, Subsection 3 and 4A and 76A and Schedule A2. Well, when I say you'll be familiar with them, I think that's a big ask. This is one of those areas where the Patents Act gets very complicated, and the reason it's so complicated is because of the EU directive on biotechnology inventions. And it's complicated by the fact that, first of all, we're talking about an exception to patentability, and then we're talking about exceptions to that exception. So there are carve-outs from the general prohibition on getting patents for certain things. But here the wording of the European Patent Convention and the Patents Act depart from one another. But for the time being, because you're answering this question, if at all, by reference to Article 53, let's stick with that. It tells you that a patent may not be granted where the commercial exploitation of the invention would be contrary to public policy and morality. You've got to pay particular attention to the wording of this provision. The question isn't whether the invention itself is contrary to public policy and morality. The question is whether the commercial exploitation of the invention would be contrary to public policy and morality. You must get that wording correct in your answer. In addition to that, there's an exception for patents for plant or animal varieties. It looks as if you're going to have to write about that, doesn't it? There's also an exception for methods of treatment. If you've got 5 seconds to tell the examiner that you know about that, all well and good, you might get a mark for it, but there's nothing going on in this scenario that requires you to consider it. Make sure the examiner understands that you can distinguish between the exclusions and the exceptions. The first relate to subject matter, and basically what the law is saying is that there are some things which can never be inventions. As such, there are plenty of examination questions exploring that, but this isn't one of them. The exceptions cover things which meet all the other requirements for patentability, but which, for various policy reasons, cannot be patented. So here we've got the exception on the basis of public policy and morality. The exploitation of the invention would be contrary to public policy and morality. And we've also got the exception for plant and animal varieties. They overlap to some extent. And the University of London Module Guide, I think, mixes them up a bit. You're told in the scenario that the patent application is for a genetically modified sheep, so the second exclusion is clearly engaged, in the sense that it's got to form part of your answer. By the way, although I don't think this would necessarily feature in your answer, if Spigot had applied for a patent for a process, or even a patent for the DNA sequence, I think they might have been on much stronger ground. But claiming the animal has potentially, at any rate, fallen into a trap. And this problem of blindness means that public policy and morality is also probably requiring consideration. And that leads us to a particularly complicated part of this already complicated enough question, which is covered in the subject guide, the module guide. The Patents Act 1977 was amended by the Biotechnology Directive. Does that mean that UK law and European patent law diverge? Well, certainly if you look at the face of the legislation, the answer is yes. Formally, there is no direct effect from the directive on the European Patent Convention. It's not a European Union instrument. There is no constitutional requirement for it to follow the directive. But there is this case in the Court of Justice, Netherlands against the European Parliament and Council, which demonstrates that there is a two-way traffic between the European Union and the European Patent Office. So despite the fact that there is no legal obligation on them to do so, the European Patent Office, working under the amended implementing regulations for the European Patent Convention, does apply Article 6, which is the important one, of the directive. The traffic coming the other way is decisions from the EPO Boards of Appeal on this area, which the Court of Justice have adopted. So basically the Netherlands case tells us that the directive applies to the European Patent Office, and decisions of the Board of Appeal apply in EU law. Interesting questions about judicial activism could be raised there, but that's not the purpose of this question. That's just how you're going to get over the significant hurdle which the examiner has put in your way and make the necessary connections between the directive and the modifications to the Patents Act 1977, which you know about, and the way the European Patent Convention is implemented. Get all that right and your first is almost guaranteed. Let's consider the public policy and morality exception, remembering that it's not the invention or the patent that's considered, it's the exploitation of the patent. There are no cases in the UK which would help us understand what this means, but of course, because we're considering what's happening in the European Patent Office, they wouldn't be relevant anyway. The University of London module guide does tell you about the way the law is applied in the European Patent Office here. So, if you've learnt the course thoroughly, you should be equipped to discuss this at least a little bit. And the short answer to this point is that the European Patent Office takes a robust view and reckons that if the claimed invention has a legitimate use, it's not the Patent Office's job to act as a moral censor or regulator. And quite right too, I think. This means that if technology is controversial, you can still get a patent for it. It's got to go well beyond that. But whoever's challenging the patent, whether it's the examiner in the European Patent Office or an opponent later on, has got to adduce evidence. There have got to be conclusively documented hazards, so the EPO says. There's a suggestion in the scenario that GM warriors have got some evidence, although it does look a little doubtful. It's worth mentioning that the examiner might see fit to refuse the application without the need for any formal opposition proceedings. In any case, this blindness problem certainly raises the possibility that the exploitation of the patent might be considered to be contrary to public policy, or actually more likely morality, I think, than public policy, but the two go very much together. Here are the cases that you might want to refer to. Well, you're not going to refer to all these in the time that you've got at your disposal. Note that the first 5 of these are European Patent Office decisions, and the last 2 are in the Court of Justice. It's important to be clear in your own mind about which jurisdiction you're talking about. The first one on the list, OncoMouse, is probably what the examiner is going to want to see as he or she scans your script. But I think you would also do well to include the Bristol case and International Stem Cell Corporation. Excuse me if I don't talk about the decisions in detail. I've got to keep this down to a manageable length. OncoMouse is also the key decision when it comes to applying the exception for animal varieties. And it tells us, and this may come as quite a surprise to you, that a genetically modified animal is not an animal variety. To impress the examiner, you would say that the boards of appeal in the European Patent Office take the view that the exclusion covers what is found in nature, and something which isn't found in nature can be patentable. Impress the examiner even more by saying that the OncoMouse decision tells us that there is a taxonomy to be considered. The highest level is animal, below that species, and below that variety. So if you can remember that proposition and work it into your answer, I think that's going to be good for a mark or 2. But I think it's one of those things you're going to throw in gratuitously rather than try and explain it. Even if you know enough biology to explain it, you're not going to have time to do so. Whether the patent's going to be excluded or not requires you to look at the claims. What's the invention said to be? And although I don't think this is necessarily the way to explain it to the examiner, but for the benefit of your own understanding, what this boils down to is the proposition that a genetically modified sheep is still a sheep, and in OncoMouse a genetically modified mouse was still a mouse, not a new variety, and therefore potentially patentable. Well, this question was clearly mainly focused on the biotechnology exceptions and made overly complicated by referring to the European Patent Convention rather than the Patents Act. However, you haven't reached the end of the answer yet. You've also got to address issues about novelty and disclosure, and how you go about doing this on the basis of the knowledge you've got is far from clear. I'd start by saying that novelty is a requirement for patentability. It's one of the 3 positive criteria, and you should have set out the positive criteria somewhere earlier in the answer just to make sure the examiner realised that you knew them. So Spigot are only going to get a patent if their invention does not form part of the state of the art. Here we're looking at Article 54 of the European Patent Convention. So if you want to tell the examiner that you're more comfortable writing about the Patents Act, you can rely on the fact that the wording and the legal principles are the same. You could, I suppose, dress it up in a different way and say to the examiner, my advice to Spigot Co is that if they get this patent, then it could be challenged in the English courts. One way in which it could be challenged would be in a counterclaim in an infringement action, claiming that the patent is invalid, but there could be a standalone invalidity challenge. But really that's a rather artificial way of turning the question round to get it onto familiar territory, and it's really not fair to be expecting you to do anything quite like that. Maybe the saving grace of this question is that by the time you get to this point you don't have time to write at great length about any of this, so you'll simply be saying that the invention must not form part of the state of the art, otherwise it will lack novelty, patent won't be granted. Be very careful with your use of the case law, because while the English courts have got to follow decisions of the EPO's boards of appeal, indeed all national courts in EPC parties have got to follow those decisions, the reverse doesn't apply. So the European Patent Office doesn't have to follow the court cases with which you're familiar, of which Lux is probably the most important one in this area. One thing you could, I think, legitimately do, if you haven't turned around the question and made it about validity so you can apply the Patents Act, you could say the Lux case illustrates how this works in practice. Because what the problem is here is very much like the Lux case. Has the invention been disclosed? Is it available to the public? Does it form part of the state of the art? You've got issues about the fact that the neighbour who stole the sheep in the first place was acting unlawfully. Would what they did with the sheep have enabled them to find out anything about the invention? I think the answer to that's a pretty clear no, but what the examiner's interested in is not clear yeses and nos necessarily. It's a demonstration that you understand the legal principles. And was any disclosure an enabling disclosure? The sheep might have been taken from the farm, but does that mean that the invention has become known to the public? Well, inevitably, of course, if you were facing a problem like this in real life, there would be many, many, many more facts that would have to be taken into account. So you don't have anything like enough information to come to a definite view about it. When the examiner says advise Spigot Co, I suppose from a practitioner's point of view, what the examiner is saying is give them some preliminary advice. Talk about the general shape of the law on the basis of the limited facts that you've got. But since you're advising Spigot, and you've just discussed the possibility that their invention has been disclosed and forms part of the state of the art, you can go on and make it impossible for the examiner not to award you full marks by mentioning Article 55, which is the EPC equivalent of Section 2, subsection 4 of the Patents Act, which gives the applicant a 6-month period of grace to file a patent application that will not be compromised by an unauthorized disclosure. So we don't think Spigot have got a problem with disclosure, but just in case they have, there's an escape route for them. Look at the dates mentioned in the exam, in the question rather. The rustling took place in August. The patent application was filed on the 1st of November, about 3 months apart. It's a signpost which the examiner has obligingly put into the question to point you to one of the issues that you've got to discuss in your answer. And I think if I can help you recognise those signposts, that's going to be one of the most valuable aspects of these talks. Thank you very much for listening. I hope you found this useful. If you have, I'd be grateful for a like, and I'd also be grateful for a subscribe if you haven't already subscribed to this channel. That'll give me the encouragement I need to produce some more of these. If you've got any questions, feel free to put them in the comments section. I'll speak to you again soon.